It gives relief in tennis elbow. We have tennis elbow, it gives relief. Yes.
From the minutes, item number 1.
Filed affidavit.
Lordship, yes.
One by the Chief Secretary, one by...
One with the police, DGP, Lordship.
Where are they? The affidavits. Anything concrete or the...
Lordship, it's complete. Lordship, if I invite your Lordship attention to para 6 of the DGP's affidavit.
Para 6 of?
DGP's affidavit.
DGP's affidavit.
23rd May. This was pursuant to the notice issued by ASP.
All this is ex post facto.
Lordship.
What is happening to actually check the thing on the ground?
Lordship,
all this is
Lordship,
reaction.
Lordship, I may again take a Lordship to para...
Where have you dealt with the details indicated in Justice Kataki's report? Where have you dealt with that? The order has reference to Justice Kataki's report.
Lordship.
Justice Kataki's report details scathing
Absolutely, Lordship.
instances. Where is that? This is one of reaction.
Lordship, para 7, 8, 9.
All of them is after the horse is bolted.
Unfortunately, Lordship, yes, that's correct.
The word on the street is there are fixed rates for looking the other way when these trucks pass. They drop the money on the road and you pick it up after the truck is gone.
Lordship, if I may invite Lordship to para 12. From April 2014 till April 2023.
How much has been collected?
No, Lordship.
Street money?
No, not the action taken by the government, Lordship. Para 12, Lordship. For a moment.
Okay.
Relevant would be Roman 1, 2, 3, Lordship. 4.
Affidavits have been filed by the Chief Secretary and the Director General of Police pursuant to the order dated
Lordship, may just draw one more attention to para 11 of page 13.
When was that order passed, Mr. Khan?
25.
On April 20, on
This order 15.5, Lordship. Para 8 of 15.5.
on April 15, 2023. Paragraph, however, comma, such order referred to the 13th interim report filed by Justice Kataki, retired, and the innumerable instances of flagrant breach of subsisting orders indicated in such report. Paragraph, neither the Chief Secretary nor the Director General of Police has dealt with such aspect of the matter, full stop. Indeed, comma, the affidavit filed by the DGP is more of what has been done after the horse has bolted. Full stop. What the court requires is for the horse to be kept safe and to close the stable door. Full stop. It does not appear that either the administration or the police has made any endeavor in such regard, as the stable doors have been left wide open with both the administration and the police looking the other way. Full stop. Paragraph. The instances referred to in Justice Katake's 13th interim report must be individually dealt with, and both the Chief Secretary and the DGP will file further affidavits indicating measures taken to ensure that there is no breach of the subsisting orders in future. Full stop. Paragraph. Such further affidavit should be filed within 4 weeks. Full stop. The matter will appear 5 weeks hence. Paragraph. In the meantime, comma, the state should also ensure that the previous coal is disposed of as per the original schedule as set by Justice Kataki. Full stop. Paragraph. Justice Kataki will keep on monitoring the situation and keep up the good work. Full stop. A further ad hoc remuneration of ₹5 lakh be immediately released to Justice Kataki. Give a date, 4 weeks hence. I didn't want to do the thing because you're not going to be here. So when you come back, you have to ignore it.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Yes. How long will it take, Mr. Dholakia? You've given him a list
Yes.
of the other heads. Where is that list for us?
May I just hand it over?
All of them can be found in that award volume.
There are separate awards, Manoj. So what we've done is we've extracted from the award. So the first part, page 1 to page 3, will be in the award volume. Then the others, Manoj, concern. Yes.
Up to page,
Up to page 3 top, Manoj.
or where you have that
Delayed. That's the last award.
page 3 top is
Just before the 13-kilometer road
Road.
Lordship, please. So
And
that
the
will be
13
part of the.
kilometer road?
In the appeal paper book, arbitration appeal number 4.
Now, in the second one, that is arbitration appeal number 4, Your
By
Lordship.
the way, the road construction was by a separate entity.
It was a JV.
It was a JV between Malaj Patel and another entity.
Very well. So it's
The-
not, Patel is not the, I noticed in the cause title that the name is different.
Yes, but it was a joint venture. They were part of the joint
Very
venture.
Patel and Advanced Construction.
It was a company called Advanced Construction and Patel.
But it's called Advance. The JV
Yes,
is
it's called Advanced, but it's a JV between
So
the.
it's an associate of Patel.
Lordship, please.
Otherwise, we'll have to, bifurcate the appearance. We are not doing that.
Lordship, please.
So that is it. And over here, it's 14-4. These are part of the appeal paper book.
Yes, sir.
Very
The
well.
next one.
And even the next one. And for the sake of convenience, we've extracted the items.
Yes. You extracted the item and indicated the serial number and the page number.
Lordship, please. And I must point out in lot 2 and 3, these entries had an annexure 1.
Sorry?
In lot 2 and 3, these entries had an annexure 1. So I have not put it here because then there is some basis there. Because your lordships had asked me that wherever there is no basis, you point out. So in lot 2 and 3, because these entries did have an annexure 1, I have not made it part of my
Very
note.
good. Very good.
So it's 3 out of 4. 3 out of 5, sorry.
3 out of 5 meaning?
In the sense, in respect of 3 awards, this discrepancy exists, which we have pointed out.
So it's only lot 1
Yes,
and
ma'am.
then the 2
Lot 1 and then the 2 road contracts.
road construction.
Lordship.
Yes. And Mr. Dholake, you have that. You'll be dealing with this exclusively.
Yes, my lord, I'll do it.
Yes.
But would your lordship be so kind as to have the award volume that my learned friend
Yes.
has not reached? Sorry.
Give us 2 minutes to get organized.
Certainly.
Yes.
But Lord, if your Lordships would be so kind as to have page 137 of the award volume, my Lord.
137, yes.
May I read, my Lord? It says the AT notes that the claimant has cited extensive arguments in support of its claim and the quantification of head office overheads and profit. The AT does not wish to reproduce the entire argument for the sake of brevity. The claimant has cited reference of CWC guidelines, which has recommended 20% towards overheads and profit. The claimant has also argued on the bifurcation of on-site and off-site overheads in its submissions and explained the importance of considering both the aspects while quantifying the claim. Finally, the claimant has cited Hudson's book on building and engineering contracts in support of its contentions. Keeping in view the specific stipulations regarding the percentage of overheads and profit at 10% each in the contract, any higher percentage cannot be considered in the computations, and accordingly the arbitral tribunal has, as per the contract provisions, considered the following CWC guidelines. And Lord, the 2 bullet points indicate what CWC guidelines have been relied upon. Now, my Lord, if your Lordship would be so kind as to turn over.
These bullet points, as you say,
Yes.
the 2 notes that are also there at page 163.
Yes, my Lord. 163 also. That also, your Lordship.
The same 2 references are there at page 161.
Yes, 161. It's 161, my Lord.
161, yes. 163 is the idle labor.
Correct, your Lordship.
Yes.
No, absolutely. So, my Lord, now kindly turn over the page to page 138.
Yes.
My Lord, your Lordships will find Roman 4. It says, as regards contractors' overheads and profits, the CWC guidelines state as follows: contractors' overheads and profit.
130?
138. 8. The next page, my Lord, after your Lordship just read 15.4, 1 and 2.
Yes, there's 3.5.
3.5, that's right.
Yes.
It says, as regards contractors' overheads and profits, CWC guidelines state as follows: contractors' overheads and profit. Contractors' overhead costs include office expenses, share of office, head office expenses, legal charges, general establishment, watch and ward, local conveyance, traveling, social welfare, salaries of managerial, clerical staff, etc., publicity, etc. In addition to the overhead expenses, the contractor has to be allowed certain amounts towards his profits. This is usually expressed as a percentage of the total estimated cost of the job. This percentage varies from job to job, but usually a 15% profit, which is what your Lordships had also indicated yesterday.
Yes.
Is anticipated by the contractors. On large jobs, a larger percentage of profit may be adequate. Since it is difficult to identify overheads and profits precisely, both these together may be provided at 20% of the prime cost for as per the state government norms in the analysis of rates. So, this is what the CWC guidelines provide. Now, my Lord, kindly turn over the page to page 140. May I read, my Lord? I'm reading serial number 10, which is, my Lord, one of the entries on which, my Lord, my learned friend is placing reliance. Serial number 10.
Yes, but you come to his chart now.
All right. Your Lordship will turn over the page to page 2. Serial number 10. Has my Lord got it?
So you're 3, 4, and 5 to his chart. You're doing it otherwise.
I can do, I'm not, since my learned friend wanted your Lordships to see it from the award, I was showing it from the award itself.
Yes.
But I can do it from the chart, no difficulty. But I will have to come back to the award because that's where, my Lord, the calculations are provided. So, my Lord, if your Lordship will kindly turn to page 2 of my learned friend's chart.
Yes.
And my Lord, where serial, the second box.
Yes.
Serial number 10, page 140, which is what I was inviting my Lord's attention to.
Yes.
And it says extra head office expenses, overheads and loss of profit, for which, my Lord, I just read the rationale. During the period of suspension of works, additional on account of. Now, kindly mark, it says as per tribunal, the work is continuing. Suspension of works is not foreclosure. Interest is considered on the unrecovered overheads through work and profit on unexecuted part delayed. What this means is, my Lord, what I had claimed was that whatever overhead expenses I have incurred, you must pay me that, and you must pay me the loss of profit during this period. The tribunal disagrees and says that right now the period is only suspended. At some point in time in future, you will complete the contract, so you will get your overhead expenses at that point in time. Right now, there's no foreclosure of the contract, and you will get your loss of profit then. But during this interregnum, when your equipment and everything is idling, you have already incurred the overhead expenses and there is loss of profit that has occurred to you. So we are going to grant you interest on the loss of profit and interest on the overhead expenses that has been incurred by you already, but which you will get at a later point in time when you complete the contract. I wonder, my lord, if I'm making myself clear as to what
You are.
Yes. Now,
Yes.
my lord, based on this, what the tribunal does is, if your lordship will now come to page 233. Of the same award volume, my lord. Has my lord got that?
Yes.
Page 233, my lord. It
Yes.
says at the top of that page, my lord, after the first four lines, it says lot, my lord, on the right hand side, it says lot 1, 2, and 3 contracts, and on the after the fourth line, it says reference 1, lot 1 claims 3, 4, and 5, and lot 2 and 3 claims 1, 2, and 3, because they are the identical my lord, claims. And it says computations for interest on overhead and profit delayed realization due to suspension period. Now, my lord, the first entry your lordship will see, I'll just take lot 1 for the moment. And your lordships will see contract amount is 67.52 crores, which your lordships noticed yesterday. Now, my lord, RA bill amount paid 28.85. So by 9th of June 2004, which is the day the suspension period starts, 28.85 crores amount was given to me. Your lordship saw, my lord, yesterday, the first figure I had given to my lord was 14.42 crores, which was up to 27 September 2003, which was the original end date of the contract. But by 9th of June 2004, a further sum of about 14 odd crores has been paid. So the total amount comes to 28.85. Now, my lord, your lordships will see this is also indicated in the next entry. It says balance value. So what they have said is what is the unexecuted part of the contract. So 6752 minus 2885 comes to 3867. This is the unexecuted part of the contract, value of the contract. Then they apply a 10% on overheads, 10% on profit, add the two up and it comes to 773. Now, my lord, the contract has stipulations that, for example, mobilization advance and all that, interest of 18% is to be applied. So they say interest as per contract 18% we will give you. So, my lord, then they bifurcate into different periods. For the first, my lord, because there are 3 claims, 9/6/2004 to 30/1/2005 is 296 days. Now, my lord, so therefore 296 days, the 773 is, my lord, 296 is divided by 365 multiplied by 18% and then multiplied by 773. And, my lord, the lordships will see at the bottom where the table is given, amount of interest on delayed OH and profit for balance due value of the work. First period is 1 crore and 12 lakhs, 89,000. Has my lord got that? Now, my lord, if your lordship will just come back, I'm just pausing here for a minute. I'll come back to this chart. Your lordship sees, my lord, this is done for all the periods, all 3 lots. Now, my lord, kindly come back to page 140, which is not or the chart entry which my learned friend had shown. And your lordships will see I had claimed 4 crore 11. And, my lord, what the tribunal granted me was 95.58. Although, my lord, it says 1 crore and 12 lakh here. Has my lord got that, my lord? At page 233, my lord, the first entry says 1 crore 12, but, my lord, the at page 140, the amount awarded is 95 lakhs. Now, my lord, this became a subject matter of a correction of the award, which, my lord, your lordships will find is at page 623 of the appeal. I'm sorry, my lord, that's in a different volume.
620.
3 of the appeal paper book. If your lordship will first have 621, but your lordships will find this is the correction in the award under section 33. And kindly turn to page 623 now. What your has my lord got 623? 623, my lord?
1 second. Yes.
Sorry.
623. Yes, sir.
Lord, 621 is the beginning of the correction of the award, and 623 on the top, your lordships will see correction sought for by the claimant 9558 and decision order of the tribunal 1 crore 12 lakhs. So, my lord,
Which
they
is the
actually
figure at page 233.
That's the figure at page 233. They correct the award, and the consequential corrections are made in the column below. That now it has to be added, and that's how the figure becomes, my lord, whatever the further.
Now, when you gave us the figures pertaining to the award,
this includes 1 crore 12 lakhs.
you included
It is included in that page 780. That figure is not, but based on this, I've cross-checked that. So 1 crore 12 lakhs is not indicated there. I can not show that. Your lordship will come to page 780. Your lordship will just see, my lord, since your lordships are on 63.
To cut the matter short, my lord, I think my learned friend appears to be right. I mean, to be fair.
Yes.
So, I don't want to take your lordship's time on
This is all, and they are similar. You have
Similar, everything is similar.
I think my learned friend appears to be right. But
Thank you. We thought as much.
We can cut it short.
We thought as much. So what we'll take into account, thank you very much. We'll not record any concession in this regard.
Lordship.
The only concession that we are recording is bias.
Yes. As counsel, I am making the concession.
Yes, and we've recorded it as such.
Lordship, please.
In fact, we've said as senior counsel, you have implicit authority, and when you make a considered concession on an aspect like this, it binds the client. That is the exact words that we've already used. So that aspect has already been covered.
I'm grateful to you, Lordship.
So this is it. So what we will do is we will disregard this part, and we'll go on and in fine what will happen is the interest, all the amount awarded as pre-reference and pendent interest will be set aside, and you will be left at liberty to make a fresh reference in accordance with law in respect of such part of the award which has been set aside. And we'll also provide that in the event, of course, that we need not, because you've got 75% against bank guarantees.
Yes. So, to the extent to which they will not now ask for refund of that money or revoke the guarantee.
We'll also say no refund.
But some time limited stipulation for them to make a reference.
Yes.
Because suppose they don't make it, then it shouldn't be that then the award
I think that's
part
fair.
goes.
That is within the period of limitation.
Yes, but
They'll make it within the period of limitation. If they don't, then you'll be entitled to seek refund.
your Lordship may clarify that.
Yes.
Yeah.
No refund if filed within limitation.
Lordship, please.
Because limitation will stop the day, the clock will start the day judgment is pronounced.
Lordship, please. Your Lordship may just make that clear. Because
Yes.
tomorrow, my lords, if they don't make a reference, it shouldn't be that they say we hold on to this money.
Exactly, absolutely right.
Wonderful. Thank you.
I'm extremely
Thank you,
grateful, my lords. It's a pleasure being before your Lordship.
We are grateful. We are grateful for the erudition and the education that we receive. Don't get this commercial matter very often over here, but
Your Lordship is too kind. my lords.
Yes. So deeply grateful.
hearing concluded, judgment is reserved, will be pronounced at 10:30 a.m. on Tuesday's date.
Lordship, please.
Grateful.
But since the other day, the question of nociter res osae and agestum generis came up, I was reminded of an anecdote. Mr. Daftari was once asked this question by Justice Hidayatullah. He said, agestum generis or nociter res osae, what does this doctrine mean?
Man is known by the company that he keeps.
He said, my lords, he says, I am not very sure, my lord. But what I think it means is that if I, Daftari, am seen in your lordship's company, I will mistakenly be called a legal scholar. Grateful.
Mr. Daftari had a better quip to a Bombay judge who was not favorably disposed towards him and had questioned his being a steward in the Bombay race club or something like that, Bombay Turf Club. So there was once a judgment that Mr. Daftari cited in that court, and there was a bug in the book.
Yeah.
And the judge immediately said that there's a bug. So Mr. Daftari, as you know, quipped that this is not the first time that one has gone from the bar to the bench.
Mr. Settleworth,
Yes.
while arguing the, again, Mr. Daftari, when he was arguing the Bombay prohibition matter, and he started by saying that if you remove the word pub out of a republic, all that you have left is a relic.
Thank you.
Lordship, please.
From the main list, item number 1.
Please, Lordship. Lords, in terms of the last
Give us a minute, please. Yes, Mr. Paul. Sorry.
Well, it's in terms of the last orders passed by this Honorable Court on 5/5/2023, Millets, we've effected service on all the respondents.
What is the matter about?
Millets, this is an appeal, Millets, arising out of a challenge made by me, Millets, regarding the composition of the WAF board. Now, I say, Millets, that the people who are
Same old matter.
no, Millets, it is a different matter, Millets. The challenge is, Millets, we are saying that the people who've been now been made members of the WAF board do not have the qualifications as enumerated under section 14 of the Act. That's the limited challenge, Millets. The learned single judge, Millets, without going into the merits of the matter, on an objection raised by some of the respondents, Millets, dismissed my writ petition on the ground that I do not have the locus to challenge it. That is the limited challenge before your lordships.
What is the qualification necessary for a challenge?
Millets, under section 14,
No, what is the qualification necessary for a challenger?
Lordship, what the
Anyone can challenge.
Lordship, what
It's like quo warranto.
Millets.
Lordship, what the learned single judge had queried, had asked a pointed question that what is the injury that you face on account of this notification? So to that, my lord, there was no clear answer, no precise answer given. On that limited ground, my lord, the learned single judge.
But if a court of law
Yes, ma'am.
is informed that a public position is being held by a person not qualified to occupy that position, immediately what is done is the writ of quo warranto is attracted. And this is not before a district court, this is before a high court.
True, my lord.
So where is the qualification necessary of the complainant?
Lordship, in answer to the learned single judge's query, reference was made by appellant to section 3, my lord, section 3 of the WAF Act. The argument placed before the single judge, my lord, was that he, as per section 3K,
Forget it, Mr. Jindal will take it to be he's an interloper. We'll throw him out. We now have the information. And since the information is with us, we ask you, if you're the state or if you're the authority, that satisfy us that these people have the qualification. He no longer participates in the matter. Let us say he's an Armenian Christian from Tbilisi. and is not even a citizen. Or let us say he's a Martian. All that is needed is for us to have the information. We treat him merely as an informant.
Lordship, my respectful submission to that would be that in that case, my lord, the writ would have to be cast maybe as a PIL.
Oh, that's form. We are the High Court. We are not playing with toys.
True.
That's form.
True.
And what is form in the interest of justice?
Very good. Very good. Appreciate that.
We'll set aside the order. We'll require it to be taken up on merits by treating to be a mere informant, because in effect, whatever may be the form in which the matter has been filed, it's circumstances leading to the issuance of a writ of quo warranto which has been raised, and that should be gone into. All the respondents are represented.
I'm appearing
They've
for
been
few
served, my lords, but
You are appearing for?
a few of them, about 6 of them.
You are appearing for 7,
8, 10, 12, 13 and 14, my lord.
7, 8, 10, 12, 13 and 14.
Yes, ma'am.
What about the others? Who is for the state?
My lord, I am appearing for respondent number 1 and 2, my lord.
You are for 1 and 2. That is the...
state, my lords.
The others have been served? Is
They have
there
been
any
served.
affidavit of service?
We filed an affidavit of service yesterday, my
Where
lords.
is that?
My lords, it has been filed yesterday on 24/5/2023.
You have it in your hand?
My lords.
And you're satisfied service has been effected?
My lords, on respondent number 6, my lords, he has received it in person. Respondent number 12 has received it on person, my
12
lords.
is represented already.
12 is here.
My lords. This is our respondent number. It's been sent by registered post, my lords, and it's delivered. We've annexed the delivery notice, my lords. One, my lords, respondent has been served by email, my lords. The acknowledgement has come of delivery.
All of them have been served.
My lords.
Mr. Jindal represents the respondent numbers 7, 8, 10, 12, 13 and 14. Paragraph Mr. Shengupto
1 and 2, my lord.
represents the respondent numbers 1 and 2. The key respondents in this case, since the impugned appointments appear to have been made by or at the behest of the state.
My lords.
Yes.
Paragraph. The short grievance of the appellant here is that despite the appellants challenging the appointment of members on the Waqf board on the ground that they do not possess the qualifications under the Awqaf Act 1995, the petition under Article 226 of the Constitution has been dismissed on the ground of the appellants herein as petitioners before the court of the first instance not having requisite locus standi. Full stop. Paragraph. There is no doubt that the court has to guard against passers-by, interlopers and busybodies wasting the court's time or raising reckless issues which need not be addressed by the court. Full stop. However, when the court is in receipt of information that persons not qualified, in accordance with law, to occupy certain public positions have been anointed to the posts, the court has merely to recognize the petitioner as an informant and ascertain the veracity of the matter. Full stop. Clearly, the writ petitioners in this case were seeking the issuance of a writ in the nature of quo warranto in challenging the members of the Waqf board on the ground of lack of qualification. Full stop. Paragraph. Even if the court were to be minded not to allow the petitioners to participate any further in the matter, the court would, ordinarily, be obliged to ascertain the veracity of the matter and ensure that members to statutory posts are appointed in accordance with law and as per the qualifications necessary therefore. Full stop. Paragraph. Since the writ petition in this case was dismissed at the outset and without any exercise being undertaken to ascertain whether the members of the Waqf board possess the requisite qualifications, the order impugned dated
Well, it's 6/3/2023 minutes.
March 6, 2023 is set aside and the matter is restored before the board of the single bench. Matter is restored before the single bench with a request to look into the merits thereof in accordance with law. Full stop. Paragraph WA number 10 of 2023 succeeds to the limited extent as indicated. Full stop. There will, however, be no orders to cost.
Highly obliged.
When I said so-and-so appears for so-and-so, so-and-so, then the third paragraph will be an affidavit of service has been filed and counsel for the appellant submits that the other unrepresented respondents have also been served.
But highly obliged.
Item number 2.
May I be pleased, Your Lordship? Your Lordship, I beg to seek another 3 weeks accommodation, Your Lordship, because the conducting counsel is not well, Your Lordship. The doctors have advised him to take another 4 weeks.
3 weeks? Yes. 3 weeks, Mr. Khan? Since the appellant seeks an accommodation for 3 weeks on the ground of appearing counsel being indisposed, let the matter appear 3 weeks hence.
Highly obliged, Your Lordship.
Item number 3.
May I please, my lord? Lordship, the genesis of this appeal can be traced back to an FIR.
Sorry,
My lord.
can't hear you. You have to increase the volume slightly.
My lord.
Yes.
Am I audible?
Yes.
My lord, the genesis of this appeal comes from an FIR which was lodged before the Pilankata police outpost under Khanapada police station, my lord, Rebhoy district. The FIR was filed on
What is it? 302 or POXO?
302 and 364.
How many did you murder?
One, my lord.
One only.
One.
Tried more, got only one.
My lord?
Tried more, got only one.
No, one only, my lord.
One only.
One only.
And what are your grounds?
My lord, I have certain grounds. My lord, the first ground which was taken is that the key witness.
Just give us an overall impression before you take us to the
My lord.
details.
My lord, the first ground which I have taken, my lord, is that the star witness, who was the sister of the victim, was never examined.
Was never?
Was never examined.
Never examined.
She is apparently the only eyewitness, my lord. And the other eyewitness is not reliable.
Other eyewitness?
Is not reliable, my lord.
Because he in his evidence have stated that he has seen a small boy, whereas the
Seen a
small boy going with the appellant, my lord, on that fateful day. But my lord, the small boy here is of 16 years of age, my lord, and his deposition has been differing at different places, my lord. So he is not reliable. The only eyewitness is the sister of the victim, my lord. No doubt she was a major at that point of time, but she was never examined, my lord. Apart from that, my lord, the entire case is of circumstantial evidence, my lord. Because the investigating officer as well as the trial court, my lord, below, they have stated that the victim had died.
What have they applied? Last seen theory?
Last seen theory, my lord. And that is
And
not
how have you undone that?
My lord, last seen, nobody has said that the victim had gone with the appellant, my lord. Nobody, except the sister, my lord, who was the one who called the victim from inside the house saying that the appellant is calling you. She was never examined, my lord. Number two, my lord, the victim's body was found in a highly decomposed manner. My lord, no DNA was done. The body was not even superimposed and a body was made, my lord.
Body was superimposed?
I have a judgment on that, my lord.
What body is superimposed meaning?
On superimposition, my lord, the skull is fitted somehow to make it look like a body. Because in this case, my lord, the skull was not on the place, my lord. It was not at the place. It was chopped off.
So what had you done? You had beheaded him?
It is said so. I have not done it, my lord. Now, I have not done it, my lord.
And where was the head found?
Nearby, my lord. Nearby. Now, the issue here is that, my lord,
did that head belong to that body?
Yes. No, the body was identified by the father of the victim by the clothes. That's it. Now, there is a different version, my lord. Somebody is saying that he was shot. The person, the main accused, who was arrested, one of the main accused, he has said that he was shot. He heard the gunshot. But now, post-mortem report says that there was a blunt injury. Another thing, my lord,
blunt injury where?
On the head, my lord, here, incised wound.
But you say he was beheaded?
Incised wound and the skull was dissipated, my lord. The skull was not on the body, my lord. Now,
it's not only the skull, it's the head.
It's the head, my lord. It's the head. I stand corrected. I stand corrected. Now, my lord, the issue here is that one of the accused who was arrested and subsequently he absconded, my lord. One of the accused. He was arrested. There were 3 arrests made, my lord. 2 are serving the sentence. The third one was arrested and he escaped, my lord. So he was declared absconded. Another 7 are yet to be arrested, my lord. And they are all apparently, as per the version of the investigating officer, are members of a dreaded outfit. Different outfits, my lord. Now, the question here is that, my lord, no DNA was done. And I was convicted solely on the ground that somebody has told that I was found there. Number 1. Number 2, my call detail records or call locations were never exhibited, my lord. That my location was in the periphery of the place where the victim's body was found on certain date. My lord, there is no answer whether the victim was having a mobile or not. Or his mobile location has been found. That has not been done, my lord. So,
you're also a member of that outfit?
No, my lord, no. And this is the first appellant, my lord. There's another appellant in the same case, my lord. Now, this
is a subsequent appeal.
Subsequent. So, the entire case, my lord, is based on circumstantial evidence. And there's a settled principle of law, my lord, that when the case is based on circumstantial evidence, the chain has to be complete, my lord. And here there are glaring examples, my lord, that I cannot be attributed to the murder and kidnapping of the victim, my lord. Because last seen theory is, the entire case is based and the judgment is based on the last seen theory, and that last seen theory is not corroborated.
Yes.
We can come with the FIR, my lord, now. The FIR was filed, my lord. I may read the FIR, my lord. With reference to this...
Tell us where the FIR is.
Page number 2 of the paper book, my lord. The typed copy is at page 2, my lord.
What is the supplementary paper book?
One is for the 313 statement of the subsequent appellant, my lord, and one is for the sentencing part, my lord. Now, FIR is at page 2, the typed copy, my lord.
FIR, when was it filed?
It was filed on 23rd October, my lord, and the victim went missing on 21st October 2015, my lord.
The complainant clearly says, my son went out from home along with Ajay Sangma.
Yes, my lord. Now, he is not an eyewitness to it. Somebody has informed me that I have seen your son. And subsequently in his deposition, my lord, he has clearly stated that he has not seen him. My lord, he says, with reference to the subject cited above, I would like to file an FIR on this date, the 23rd October 2015, that on 21st October 2015 at about 10 a.m., my son went out from home along with Mr. Ajay Sangma of Chibra village, and he has not returned home since then. On 22nd October 2015 at 11:10 a.m., I received a phone call bearing number so-and-so demanding...
You are a resident of Chibra village. Where is Chibra village?
In Ribhoi district, my lord. A sum of so-and-so for release of my son. I also noted that they communicated to me in Garwan Assamese language. I was warned not to approach the police for help. Therefore, I urge. Now, my lord, to my lord's query that the complainant or the informant has clearly mentioned the name of the appellant, my lord, may kindly come up to page 5 of the paper book, my lord. Now, this is the first information report, the form under section 154 of CRPC. It has been mentioned that there are unknown suspects.
Yes.
Yes.
Naturally unknown suspect.
Unknown. But
he has not alleged over there you have killed him.
No, my lord.
He has said that he has gone out with him.
Exactly, my lord. Now,
but he doesn't know that you have killed him.
No.
In fact, doesn't even know that he's been killed. It's a missing person diary.
Yes, my lord.
It's not a
murder
diary.
No, but he has said that he has received an information about a ransom call, my lord. My lord, then I was arrested on 30th-10-2015, my lord.
Huh?
30th-10-2015, I was arrested.
Arrested?
On 30-10-2015, my lord.
And you've been in custody since?
Since then, my lord. I've been in custody.
Good. Now, that's how many years gone? 8 years gone? What have you got?
Life, my lord.
It's another 7-8 years to go.
My lord.
How old are you?
I'm about
at the time of the incident?
At the time of the incident, my lord, I was 1990. I was born, my lord.
1990, you
1990,
were born.
About.
Yes. So you were 35.
35, my lord.
Or 25, rather.
23, 25, my lord.
Yes.
Now, my lord, after investigation.
So when was the body discovered?
Body was discovered on, my lord, 3/11/2015, my lord. From Amazonga jungle, my lord, Gwalpada district. Amazonga jungle.
Where is that?
In Gwalpada district, my lord, of Assam.
Of Assam.
Of Assam.
And what is the name of the place? You said in Gwalpada. What is the name of the place?
Amazonga jungle, my lord. It is a jungle, it's a reserve forest, my lord.
Amazonga.
Amazonga.
Yes.
My lord, I may be allowed to come to the charge sheet, my lord.
Page?
It's page 21 of the paper book, my lord. My lord, I may be allowed to read this charge sheet, my lord, because it has a bearing on the entire deposition as well.
Yes.
My lord, the prosecution story of the case is that on so-and-so, 23/10/2015 at 5 p.m., one Rahim D. Sangma, son of so-and-so,
yes,
of
21.
21, my lord.
Yes.
Yes. Is the charge sheet, my lord.
Brief story of the case.
Brief story of the charge sheet, of the case, my lord. P.S. Khanapada, P.O. Pilankata, District Reboy, Meghalaya, appeared at the OP and submitted a written FIR to the effect that on 21/10/2015 at 10 a.m., his son, Master Prem D. Sangma, 16 years, went out from home along with Ajay Sangma of Chibra village, Khanapada, P.O. Pilankata, so-and-so, and has not returned since then. However, on 22/10/2015 at 10 a.m., he received a call on his mobile number so-and-so from unknown mobile number so-and-so and demanding the sum of rupees 10 lakhs as a ransom for the release of his son, and the person were communicating in Garo and Assamese language and also warned not to approach the police for help. The case was started and I, S.I.K. Thapa, took up the investigation of the case. During the course of investigation, visited the PO is that Umtringa village, PO Pilankata so-and-so, which is approximately 3 kilometers from this PO towards south, held confidential inquiry and learned that on 21/10/2015 at 10 a.m. Master so-and-so, son of so-and-so, was at home. Meanwhile, Ajay Sangma of Chibra village, PS Khanapada, PO Pilankata district, was standing outside the house of Prem D. Sangma and asked his sister Miss Rani D. Sangma, 11 years, to call his brother outside as he wanted to talk to him, who was at time was inside the house. Accordingly, she went and called him, and her mother Dorchon D. Sangma stated that I did not see the appellant coming and calling my son. But here the investigating officer says so, my lord.
No.
No, my lord, inside
If the mother's deposition is, I did not see the appellant calling my son,
my lord.
then that is completely in sync with what he says. Only one person saw you calling the son, calling the brother,
My lord.
which is that 11-year-old sister.
Sister, my lord.
And it was thereafter that out of curiosity that the mother came out. So when the mother came out and saw you, she could not have heard you call for the brother. She just saw you standing over there.
But
And that is what he records. She went and called him, and her mother, out of curiosity, went at him and was standing near the gate. So all that the mother did was to see you near the gate. We'll look at a deposition later.
my lord, then the victim
For a
went
while they had a conversation and left, and was seen
traveling in a
traveling in a commercial vehicle, white magic van,
number not known, proceeding towards
Boshishthacharya.
my lord. My lord, on further inquiry,
Since then, Prema has not been returned back.
yes, my lord.
So it was both, maybe the sister also, and the mother who saw you accompany.
Well, this is what the charge sheet says, my lord.
Yes.
We'll see to the deposition as well, my lord, if permits.
We'll look at that.
My lord.
Then further, master was kidnapped by applying.
By applying inducement by deceitful means.
Notice the victim's father received a phone call.
My lord, then it comes after the phone call obtained from service provider for the interest of the case. On analysis, conversation had started from the date 22/10/2015 at 11:10:03 a.m. up to the date of 27/10/2015 with the complainant mobile number so and so. Also received the application form for the mobile number so and so, which was in the name of Srimati Payal Mahato. Now, this could have been, my lord, as the IO says, was a fake SIM, my lord. Because he tried to trace this number, but it was traced back to somewhere in Nagaland, my lord. And he had sent a WT message also, it was not replied back. Now, I may come down to the last part of it, my lord, at the same page. Examined number of witnesses and engaged source. During the further course of investigation, accused Ajay and Sangma was arrested and taken into police custody. He was thoroughly interrogated while in custody, and he told that he and victim P.D. Sangma had been kidnapped by some unknown person from Vasishtha Mandir, and he was shot twice by the unknown person in where he pretended to be dead. He also showed his woolen jacket to prove that he was shot, as it has got torn cut on the right side of the jacket. Accordingly, in order to verify his statement, the woolen jacket was sent so and so, but in order to determine whether the torn cut was actually caused by the gunshot. However, on receipt of the forensic science laboratory report, Sri F. N. Lalu so-and-so opined that gunpowder residue could not be detected, which means it had no gunshot. On further interrogation, he revealed that he has made his own story in order to avoid any suspicion detection from the police. He was seen going out with Prem D. Sangma on 21/10/2015 by the witness Srimati Dorchon D. Sangma and Dear Sangma. Now, Dorchon D. Sangma is the mother, my lord, and Dear Sangma is his cousin, my lord. He also revealed that the whole plan was constructed by the person Anthony G. Momin for kidnapping the victim so-and-so, and he was offered an amount of 10,000 rupees. Efforts were made to arrest Anthony G. Momin, but in vain. The accused Ajay and Sangma expressed his willingness to lead the police party to arrest the other accused. On his leading during his period in police custody, one of the co-accused, the second appellant, my lord, was arrested from village Borjhar, Garopada. Now, after a few lines, my lord, this is the narration. However, they denied in telling the truth who killed the victim, but they expressed their willingness to lead the police party to recover the dead body of Prem D. Sangma on their leading in presence of the independent witnesses, so-and-so, my lord.
Who?
Independent witnesses, my lord, they are the headmen.
Presence, leading. So both appellant in both the matters, they led them to the
recovery of the body, my lord, in the independent. Now, my lord, the police says that they had made a disclosure to them. Now, the disclosure has not
Section
been...
27.
Section 27, my lord. But now, the investigating officer himself says that we had to search for the body.
Yes,
not a
search for the
particular
body
place
means you're in a jungle.
My lord.
In a jungle, you take them where and then they have to search.
Search.
It's over an area.
My lord.
There could be animals which could have dragged the body.
No, there's nothing on for the postmortem, my lord. There's nothing on postmortem about the animal or anything, my lord. Second thing, my lord, once, even if it is believed, my lord, that the disclosure has been made, the disclosure has been made before the police, my lord. And police at one time is saying that Ajay Sangma led us to the body, and the second time they say Akut Marat led us to the body. Now, when a disclosure was made, my lord, the investigating officer did not record the disclosure. Number two, my lord, when the disclosure was made and they were apparently asked to trace the body, my lord, the investigating officer did not take any magistrate or a gazetted officer with them. They were independent witnesses, the headmen of the locality, my lord. Now, another part is that when it comes to that, there is a theory that he was shot, the victim. But the postmortem report says otherwise. But on the ground, neither the murder weapon was seized nor any empty cartridges were seized, my lord. If we believe both the theories, that either he was shot or he was attacked by a blunt weapon, my lord, nothing was seized from there. Now, my lord, with this we come to the deposition, my lord. PW1 is the father and also the complainant, my lord, Rahim D. Sangma. I received summon to depose before the court. I know of the case as I am the complainant of the instant case. Page 32, my lord, of the paper book. My lord, I may read it, my lord. I received summon to depose before the court. I know of the case as I am the complainant of the instant case, and the deceased victim Prem D. Sangma is my son. On 21/10/2015 at about 8 a.m. my deceased son went out of the house and was missing since then. I was informed by the brother of the accused, Ajay Sangma, that my deceased son went with accused Ajay Sangma in a passenger vehicle. Thereafter, I received a phone call from the kidnapper and demanded rupees so-and-so as ransom money for release of my son on so-and-so at about 10 a.m. The kidnappers conversed with me in Garo and Assamese language. They asked me to pay the ransom money or they will kill my son. And they also threatened me and asked me not to inform the police. Thereafter, we tried to trace our son but failed to locate him. So on 23/10/2015, we lodged the FIR before the in-charge Pilankata Police Outpost. Exhibit 1, so and so is my signature, and accused person Ajay Sangma was arrested by Borjhar, Garopara, Gwalpara district, and thereafter the police arrested Akwit Mara. My deceased son was recovered from a jungle at village Borjhar on the lead of accused Akwit R. Mara. My lord, charge sheet says that I led the police, and PW1, being the father, also accompanied the police, my lord, to recover the dead body, and he is saying that appellant number 2 led us to the recovery of the body. We recovered our son. The dead body was taken to Nongpur Civil Hospital for post-mortem examination. After PM examination, the police handed over the dead body to me, exhibit so and so. Cross, my lord. It is a fact that I lodged the FIR after 2 days of the incident. On the day of missing, my son was wearing army print full sleeve t-shirt and a half pant. It is a fact that at the time of lodging the FIR, I did not mention any name, as I did not know who committed the offence. It is a fact that I accompanied the police only on the day of recovery of my deceased son. It is a fact that initially I do not know from where the accused person were arrested, but later the police told the accused persons were arrested from the same village, Borjhar, Gwalpara. My deceased son was wearing the same cloth at the time of recovery. Now, apart from the identity, the only identification of the dead body, my lord, was with the clothes he was wearing. Nothing more than that. Now, I may take your lordship to page 34, my lord, of the deposition of PW2, who is the mother of the victim, my lord. I received summon to depose before this court. I know of the case as the deceased victim Prem D. Sangma is my son. On 21/10/2014, about so and so went out of the house and disappeared since then. Later at around 10 to 11, one person, namely Dear D. Sangma, informed me that he saw my deceased son left with Ajay and Sangma in the village. Now, this is the deposition, my lord. She is admitting that one Dear D. Sangma informed him that he saw the son of the PW2, my lord, going out. She does not mention that she has seen, my lord. My husband received a phone call so and so and released of my son, and also threatened my husband if he fails to pay the ransom money, they will kill my son. Thereafter, my husband reported the matter to the police. I do not know that the police arrested the accused person who are involved in the case, and I also suspect that there is an arrested person who committed the crime. The police have recorded my statement. Now, in the cross-examination, my lord, PW2, the mother of the victim, have stated, it is a fact that the FIR was lodged after 2 days of the incident. The distance from my house to the police outpost is 20 minutes distant if we go with the motorcycle. I do not know if my husband mentioned the name of the accused person in the FIR. I saw when my deceased son went out from the house, we just finished our breakfast together. It is a fact. I did not eyewitness when my deceased son went out with Ajay Sangma in the vehicle. It is a fact that I did not talk with the kidnapper on the phone. But it is my husband who spoke with the kidnapper on so and so. I was informed by Dear D. Sangma that he saw only Ajay Sangma and my son in the village. Beside Ajay and Sangma, there are no other person involved in the case. Now, here, my lord, what the charge sheet is stating that the PW2 mother had seen, it does not stand, my lord, because she has admitted she has not seen. Now, PW3, my lord, is the one of the eyewitness, my lord, Dear D. Sangma. I received the summon issued to me. It is at page 35, my lord, of the paper book. My lord, he stated that I received this summon issued to me by the honorable.
Just a minute, please. Yes.
My lord, I received this summon issued to me by the Honorable Court. I know Ajay and Sangma as he is related to me. My mother is the elder sister of Ajay and Sangma's mother. I do not know Shri Prem D. Sangma, the victim, my lord. I saw the accused Ajay D. Sangma along with one small boy at around 8 to 9 a.m. inside the magic vehicle proceeding towards Charairali, Assam side. I know the father of the small boy. Now the small boy, it has been interpreted that is the victim, my lord, but the victim is of 16 years of age. Who was with the accused person Ajay Sangma? The father of the small boy is Rahim Sangma and he is a resident of Umtrinka. The father of the boy victim asked me if he had seen the victim. I said yes. Now PW1 says that PW3 informed him. Now here he is saying the father asked him, my lord. I saw the victim sitting in the magic vehicle, four-wheeler, along with the accused person, Ajay Sangma. Thereafter, I did not see the victim. My statement was recorded by the police. I know that the victim boy has been killed. I saw the victim boy last with the accused person, Ajay and Sangma. The statement was recorded by the magistrate and I gave the same statement as I deposed today in court. Exhibit 3 so-and-so. I do not remember the date, month and year of the incident. The father of...
Some doubt. Appears to be some doubt.
The cross I may be allowed to read, my lord?
No, just a second. They are slightly distracted today, but there appears to be some basis.
My lord.
Do it next week. Slightly distracted.
My lord. My lord.
Do it next week. There appears to be discrepancies.
There are, my lord.
Which we have to probably not disregard. Dear Sangma is the... Dear Sangma is not related to the victim.
No.
And Dear Sangma is a person who, according to the mother...
Yes, my lord.
Yeah. Next week, Mr. Bhattacharjee.
My lord.
Keeping it next week.
My lord. Yes, yes.
Let the appeal appear next week. Give it Wednesday.
My lord. Very well. My lord, same order for appeal number 4 also.
Yes, same. We'll look at one and then on the basis of one, if there's something more about the others. If we are acquitting, both will get acquitted. But if we are convicting one, then the other will have to make out a case for his acquittal.
Separately, my lord.
Already, if first one is acquitted, then second one will definitely be acquitted.
First one
is the joint Sangma, my lord. If my lord,
Ajay.
Yes, Ajay Sangma. If my lordship decide that he should be acquitted, then
second one will go.
Second one will go.
Not much material. Not much material.
No, my lord.
The sense is that he did it, but the material may not be there. And we can't go by sense over
I'll try to satisfy your lordship, my lord.
hard evidence.